Eli Lilly.
My Lords, may I now turn to the question of scope of protection and the law relating to that?
Yes, of course.
And if I might address you under these heads. First, in relation to the English law and what I will call Amgen and the road to Amgen, encompassing CANIC and Improver. Secondly, the EPC, the purpose of it and the degree of harmonisation of the law that it suggests. Thirdly, to draw your Lordship's attention to some of the observations made in the cases in other EPC countries concerning their own law, and make some observations on the academic commentary, and then address the question of whether or not the general approach of Amgen requires modification or explanation. I'll then turn to the question of prosecution history and the use that may be made of the file, and then we'll turn to the foreign laws on which Mr. Raphael will address you on two of them, and then conclude with the indirect infringement case. In the course of the submissions on the EPC, Mr. Raphael will also address you on some of the travaux to the EPC that are relevant to the case, if that's acceptable to my Lords. So that's the roadmap for this morning. And may I start by inviting you to take up the Authorities Bundle, Volume 1, which contains Amgen and the road to Amgen, and start with CATNIC, which is where all of the issues that we are centrally concerned with in this case actually originated. And if your Lordships turn to Lord Diplock's...
As a matter of principle, how safe is it? Forget the authorities, because we are the authority, but as a matter of principle, how safe is it to rely on a case which was decided on the law prior to the EPC, prior to the 1977 Act?
Well, my Lord...
Some might say that's the beginning of the problem.
My Lord, yes, some might say that is, and I'll come and...
You want to deal with that later?
I will certainly deal with that.
Don't let me interrupt you. You carry on with it.
All I was going to say is that those of higher authority than me, at least, namely the Court of Appeal, have, of course, said that CATNIC is consistent with the protocol.
That's why I say, that's why I put it the way I put it.
And indeed, Amgen itself might be said to confirm that general proposition. My Lord, the question of safety, though, and let me deal with it head on, is an essential question, because it is at the crux of all of the issues. If one takes the approach that the EPC has effectively swept away national traditions entirely and has effected what might be called a complete and absolute harmonisation as to means rather than result.
I might say tweaked rather than swept away, but I take your point.
Then one might say it is wholly unsafe to look at any national tradition. And that would be the case in every EPC country. No EPC country could draw on its national approach at all. And the approach in Schneidmesser would be as sweepable away as CATNIC, and the approach in Spain and France and so forth would also be as sweepable away. Our submission, as your Lordships have...
These approaches are presumably not done with a conscious aim of departing from the EPC.
No, in fact, absolutely to the contrary. The approaches are done, as your Lordships will see, with a conscious aim of compliance with the EPC.
And if they've left a different result, something's gone wrong. And maybe we should all sit down at a table and work out a common approach.
And I will show your Lordships where we've got to on this, because if one looks at the academic literature or the commentaries in relation to this, there's a group of those who are in the we're not harmonised enough, we should all be sitting down and listening to each other much more. And there is a group of those who say, well, actually, we are listening to each other really rather a lot, As I'll show your lordships, there is an enormous amount of mutual learning from the different traditions that takes place here.
So you say, if
don't want
anything,
to be too miserable about it.
You say, if anything, the right approach is not to sweep it all away, but to start with Catnic, and then, insofar as one makes adjustments by looking at other. I mean, the only effect of taking into account other jurisdictions has to be making some changes, or possibly making some changes. Because otherwise, there's no point in looking. But equally, it's not just us realigning ourselves with Germany alone, or even Holland, Germany, and Italy. It's a bit of give and take.
Well, not only is it a bit of give and take. If your lordships look at the Schneidmesser Quintet, which is the locus classicus of the modern German law, which we'll come on to, so far from them saying we're ploughing our own furrow, their approach is, well, actually essentially agreeing with the English court. They specifically make reference to the approach in Catnic rather than saying it's fundamentally erroneous. They say, well, actually, we're doing something similar, which relates to the point I made right at the outset yesterday, that one has to be a little bit careful in this case about what might be called the intensity of harmonization, that any given court seeks to draw from the EPC and then seeks to export to other territories.
Yes, the danger is we find ourselves aligning ourselves with Germany when they're aligning themselves with us, and we sort of change sides.
Well, your lordship has actually put your lordship's finger on the point, because it might be said that just as the German court was aligning itself with us, we were, in a sense, aligning ourselves with them. And your lordships may have picked up an amusing interchange between Lord Hoffman and Dr. Meyer-Beck, who were as it were, the lead interpreters on interpretation, respectively, at the time. Because Lord Hoffman didn't decide Amgen in isolation. According to the academic work, he sent a copy of the draft in Amgen to Dr. Meyer-Beck for his comments beforehand. Now, one might say that is a fairly intensive form of judicial cooperation. It's not a question of ignoring what other people are saying. And his observation, Lord Hoffman's observation when Dr. Meyer-Beck came back, was that, as far as he could see, the only real difference between the two traditions was that he'd been brought up with Oxford philosophy in the 1960s, and Dr. Meyer-Beck had been brought up with Hegel. Now, you might say that that's a somewhat abstract way of putting a distinction between the two. But the more serious point that arises in relation to that aspect is that this is not a situation where judges have their fingers in their ears with respect to the traditions of other EPC member states. They are very alert to them. But one thing that I shall show you in the commentary in due course is that they are all equally alert to the same set of issues. One is granting fair protection to the patentee and taking due account of equivalence, and the other is how you give proper certainty to third parties and how you give effect to the language of the patent used to that end.
Is there a difference between them on the question whether this process is to be described as a process of construction?
Yes, there is, although I will show, my Lord, a little bit later on in the morning, if I may, an observation by the Advocate General to the Dutch Supreme Court, who's one of the leading jurists in the field of patents in Europe, but particularly in the Netherlands, which is a very important forum, where he says, actually, in a way, I prefer this way of looking at it as a matter of construction, that there's the English approach. But to answer my Lord's question directly, there is a difference, but as I started to say yesterday, it's a difference which is more apparent than real. And if I go back to the English law cases and show your Lordship how that approach developed and was then incorporated into Amgen, I can perhaps explain to your Lordships why it is actually more apparent than real.
All right.
Okay, I'm sorry, we've interrupted you. We're taking us to Catnic.
No, this is very useful, and I would have to say everything that I was going to say that I've just said in any event.
Right.
So if we go to Catnic at 242 in the report, MS 2450 in the hard copy. And my lords have seen this yesterday, but it's perhaps useful to make some observations on it, because it contains a useful potted account of how matters got to the construction turn, if I may put it like that, in the light of the previous law. Going back into ancient history, of course, until claims were introduced in the latter part of the 19th century, effectively what happened was that a patentee would describe their invention, and then they would leave it up to the court to decide whether or not there had been use of the invention by the alleged infringer. And that was regarded as unsatisfactory. Claims were introduced, and the consequence, at least in English law, was that the early life of claims was then to treat them literally, and to say, well, the patentee must have meant exactly what they said, and to treat the scope of equivalence as limited. Now, I say that with some qualification, because I have not attempted to go through all of the cases, obviously deciding whether or not there was a degree of flexibility there. And in this area, it can be somewhat susceptible to imagining that the law was as it was as a result of looking at particular cases without looking at a complete tapestry. And I shall show your lordships the risks of that, even in relation to the improver case shortly. But that was certainly the perception of English law, that there was undue literalism. And that approach of undue literalism was then addressed in the 1960s by two judgments of this House's predecessor, van der Lilly and Rodi and Weinenberger. And broadly speaking, what they said was they adopted what might be called the two-step approach. Look at literal infringement, and then consider whether there is infringement according to the pith and marrow doctrine. It was not expressly described as an equivalence doctrine, but you could see it. You could see the distinction between the two aspects of literal and one might think of it as core and penumbra, which were very distinctly analysed. Now, Lord Diplock in Catnick effectively said, look, that's not quite the right way to think about it, but the words that he used were quite carefully chosen. And your lordships see that at between lines 25 to 32.
On page?
On page 242 of the report.
Thank you.
Where he said, my lords, in their closely reasoned written cases in the House and in the oral argument, both parties to this appeal have tended to treat textual infringement and infringement of the pith and marrow of an invention as if they were separate causes of action, the existence of the former to be determined as a matter of construction only, and the latter upon some broader principle of colourable evasion. There is, in my view, no such dichotomy. There is but a single cause of action, and to treat it otherwise, particularly in cases like that, which is the subject of the instant appeal, is liable to lead to confusion. So, effectively, the approach that was taken was not to deprecate as such the dichotomy, but the practice that appeared to have arisen of literal and then colourable evasion. And he goes on to talk about the van der Lilly case, no textual infringement borrowed from the speeches in the Heyrate case, that's van der Lilly's, and where the origin of that approach can be traced. And then Lord Diplock goes on to say, and this is perhaps the part that is the origin of the subsequent law, patent specification is a unilateral statement by the patentee in words of his own choosing, addressed to those likely to have a practical interest in the subject matter, by which he informs that them what he claims to be the essential features of the new product or process for which a letters patent grant him a monopoly. It is those novel features only that he claims to be essential that constitute the so-called pith and marrow of the claim. Patent specification should be given a purposive construction rather than a purely literal one, derived from applying to it the kind of meticulous verbal analysis in which lawyers are too often tempted by their training to indulge. And that is obviously the origin of the purposive construction approach. And he says there, the question is whether it will be understood that strict compliance with a particular descriptive word or phrase was intended to be an essential requirement, and that any variant would fall outside the monopoly claimed, even though it could have no material effect upon which the invention worked.
Right.
And all of that is trite law, but one sees the origin there, and it's important to have that as the foundation, of saying here is essentially a unitary question. And it's a unitary question in this sense. It may not be unitary in terms of the analysis that one performs to determine whether or not there is infringement, but that ultimately there is a question that needs to be addressed, namely, given the wording of the claims in the context of the specification, is this purported infringement in or outside the scope of the claimed monopoly? And that is why one can, not without justification, describe the ultimate task as a question of construction. And my lords see that a little bit later on.
What is the question of construction? There are two possibilities on there, perhaps more than two. One is what is being claimed in the language of the claim, and the other is what aspects of the description in the claim are being treated as essential. It does occur to me, and there are turns of phrase of Diplock which suggests that he may have been thinking in these terms, that there are actually, the problem arises from an attempt to elide those two things. The meaning of a helical spring is entirely clear. The question whether it is essential that it should have the particular features, those particular features of the description and the claim, is a different question. They may both be questions of construction, but they're not the same ones.
My lord is absolutely right. And in fact, that is, in a sense, exactly what Lord Diplock did in the Catnett case, where he started off looking at literal infringement. Obviously, there was no literal infringement because he construed, because the literal construction of vertical is at 90 degrees and no divergence from the two. But then in the section on purposive construction, when he comes to ask the question, notwithstanding the fact that there isn't verticality, should the patentee nonetheless be taken to have excluded variants?
But that's not construction, is it? It's not what it means. Nobody could conceivably say that the improver claim extended to a rubber rather than a spring component. It's a matter of construction means, what does this claim mean?
Your lordship is right in this sense, that no one could conceivably say that if an invitation says come at 8, coming at 9 was compliance in some contexts, but they could in others. And the reason is that concealed within the question of construction in every case, and what might be, in a sense, a meta question of interpretation, is the question of the degree of strictness that a term is said to connote. Now,
whether it is essential to the inventive step that is being described. I mean, a process of construction can't lead you to the conclusion that a helical spring is the same as a rubber rod, but a process of construction could lead you to the conclusion that the essential invention being described is a process for grabbing hairs from the skin and pulling them out. And whether it's done by a helical spring is inessential. Now, of course, that wasn't the outcome in that particular case, at least not in England. That is the separate question, and it can be described as a question of construction. The one problem about it, as it seems to me, is that if it's a question of construction in any sense, it's got to be decided as at the date of the patent, or priority date at any rate. And the continental jurisprudence seems to suggest the date of the infringement.
Actually, there's a mixed
it may be that one
approach
can reformulate the question to accommodate that, but
Well, you have to some extent to spring forward because you have to identify the infringement.
Well, indeed, and I'll show my lords the continental spread. It's actually quite usefully set out in a table as to how it's done.
Anyway, sorry.
Anyway, in any event, the point that my lords have, in a sense, both made in different ways is that there are ways of being right in describing this exercise as an exercise in construction, and there are equally ways of being wrong.
And one comes back to Lord Sumption's box point. You say
as an exercise.
You can call it construction or something else as you like, but you're doing the same thing.
Exactly, you're doing the same thing,
yes.
And the fact that you're doing the same thing is, in a sense, the take-home.
Yeah, exactly.
of this.
What you call it doesn't matter.
What you call it actually matters less.
Well, it matters to this degree. If you calling it construction is, as I think Professor Laddie says in the first of his two articles, calling it construction does invite you to say, well, is this within the four corners of the language? And it may not be, but still be equivalent in a legally relevant sense.
My lord, that's if I may say so, a characteristically useful formulation. And
how do you get out of construction a conclusion, though, that if a particular element is not essential, then you look at some wider concept of what is essential?
Well,
that's the difficulty I have. I mean, it seems to me a rule of law, really, which I think it takes us back to the beginning of where we were when Lord Newburger's first question.
Well, this may be resolved by how one identifies the skilled person to whom the language is addressed. It may be obvious to the skilled person that some aspects of it are colouring and flavouring and others are actually essential.
My lord is absolutely right, and indeed, in the last passage in Catnick, to which I would invite your attention, that is effectively exactly what Lord Diplock did.
Well, it's those novel features only that he claims to be essential.
Indeed, but the important aspect of that is that, at least in that case, there was a reasonable possibility of considering vertical in a loose and a strict sense.
Yes, that's only because you know a lot of science and that there isn't much difference between something which is truly vertical and something which is 6 or 8 degrees
absolutely.
off. So you have to feed in a lot of scientific facts which aren't actually mentioned as a matter of construction in the patent at all.
Absolutely, but if you feed in one other important fact, which is that one is construing the specification not through the eyes of the chancery lawyer, but through the eyes of the skilled person who is deemed to come to the specification with common general knowledge and therefore an understanding of what matters are likely to be important and not important. That, in a sense, helps you solve the problem. And that is why Lord Diplock said to a geometer, if one's concerned with a question in that context, where it's perfectly possible to have a situation where vertically means vertically. If one thinks about certain aspects of laser physics, you might say, I want not
a minute of arc.
A minute of arc off that point, and the reason it's got to be that is the following. In contrast, In the building trade, without undue discourtesy, it might be said that some might say, well, upright enough to work in the context of the particular lintel that was contemplated was sufficient. And that is all that Lord Diplock was doing in
to pick up your point, your elegant example of the invitation, if I say come at 8, you can come at 8:30, but if I say come on the 23rd of June, you can't even be a day late.
My lord, that is exactly right. And if one says, here is a statutory requirement to file a document on the 23rd of June, it probably wouldn't go down that well if you said, well, you know, it was a colourable variant, it was the 23rd of July or whatever it was. In context, it didn't really matter.
Reverting to patents, though, are we therefore getting back to something I think was Lord Sumption, maybe another of us said, the ones trying to identify the inventive concept?
One is trying to do a number of things. One is to identify the inventive concept, but one is also identifying the extent to which, from the perspective of the relevant skilled person or team, features of the claim and the claimed invention would be regarded as having technical significance.
Well, that's the same. That's essentially the same as asking what is the inventive step, isn't it?
It may not be the same. It may not be exactly the same question, because there could be a situation where there is an inventive step, but nonetheless, someone says, well, actually, let's suppose in Catnick, the question was, well, what we want to do is to have a lintel where the upright is, where all the forces are directed through the material of the upright, so that there wasn't an angle. You had to ensure that it was that the actual upright had the forces going down.
And in that case, one would conclude that it had to be vertical.
Exactly, and there may be reasons for that, which may have nothing to do with the inventive concept, but they may have to do with the way that a skilled person would read the specification in the overall context. So if I can then turn to Improver and just make a few observations on that. That's the next tab. And if your lordships would just go to page 189, that's MS 2462 in the written bundle. End of the page. The end, therefore, the question is always whether the alleged infringement is covered by the language of the claim. This, I think, is what Lord Diplock meant in Catnick when he said there was no dichotomy between textual infringement and infringement of the pith and marrow. And he agrees with Lord Justice Fox and his observation in Anchor Building Products. Secondly, although it is right that this was Catnick was a case under the Patents Act 1949, as I said to my lord earlier, in Improver, what's recorded is at the interlocutory stage, the Court of Appeal said that the approach in Catnick was the same approach as that laid down by the protocol. And the tests which were then applied were obviously the now familiar ones. If you turn over to 192-2465,
Yes.
Under the second test,
Yes.
second paragraph, perhaps I could just invite your attention to that and invite you just to read that second paragraph. I do not think, down to inquiry.
We read that yesterday.
You may have read that yesterday. And then,
What's
the point that I would just pick up on is that this test is not inconsistent with a finding that variants that are unknown and indeed unknowable at the date of the patent can nonetheless be analysed perfectly effectively by reference to whether or not they whether their characteristics would have been obvious had they been known.
Yes.
At the date of the patent. So there's no difficulty about that in principle, nor indeed any unfairness in performing the assessment in such a way that it takes account of later acquired inventions but also does that in a way that preserves consistency for the test throughout the life of the patent.
Well, the analysis in the first two paragraphs under the heading of Test 2 is very much directed to what is the essentially inventive step. And it was really because the use of the rubber rod as an alternative to the helical spring was itself an inventive step that he reached the conclusion he did.
Well, subject to this point, the infringement generally is not regarded as dependent on whether the variant makes use of the inventive step or not.
Or whether it makes use of a new invention.
Exactly. And the reason I say this is because there is a risk in looking at this from the perspective of the inventive step rather than, as was formulated here, the way in which the invention works, taken as a composite.
And the fact that the variant is not itself inventive in the sense of inherently patentable isn't a test you'd apply.
Absolutely. That's neither here nor there.
That's too steep a test.
Yes, absolutely.
I mean, what he seems to, when he refers to the rubber rod as an inventive step, I don't think that he's suggesting that. I think that he's simply using it as a test to decide whether it's an inessential variant of the process described in the claim.
My Lord is absolutely right. Of course, these questions in practice are whatever linguistic formulation you choose under this head, you're always faced with the same problem. At what level of generality is that which I am concerned with to be applied? And there is no way you can get around it. You can formulate as many Mitchison questions, EPC 2000 questions, Alexander questions. You're not going to dodge that issue because one way or another, that is an issue which is going to be central to the evaluation of whether it is obvious that an invention works in the same way or whatever formulation you choose. So if one thinks one can get round this problem by a linguistic formulation that is a cunning plan, as it were, it's not going to work on this front. And that's one of the reasons, my lords, why I say one's got to be a little bit careful with trying to reformulate Amgen, because if one does try and reformulate Amgen in that way, rather than simply saying, well, this is what Amgen was trying to get at, one doesn't solve the problem insofar as there are any problems on this head.
Can I just get my head around this head? The first one is entirely neutral. Does the variant have a material effect? The second one, would it have been obvious? This passage clearly shows, does it, states that you're not concerned with whether it would have been obvious at the date of publication of the patent. You're concerned whether now, if a skilled person had known at that date of this possibility, it would have been obvious to a skilled person that it would work in the same way.
Exactly.
So foreseeability at the date of the patent application or publication is irrelevant.
Exactly.
And
Foreseeability of the variant is
exactly
irrelevant. But foreseeability at the variant today, foreseeability as at the time of the priority date, you have to stand at the priority date and be fed the particular variant, even though it may not have been known.
if you've been given the variant, then you have to ask, do I realise that it would work in the same way?
My lords, that's exactly right.
So, but then the question of foreseeability seems at the end of the paragraph to be fed into the question of construction. Well, that's a critical point, isn't it? The question of construction is a sort of clawback from this.
Or whether you call it construction or not.
Yes.
Well, we would say no. And if you look at the way in which
I mean, if the skilled person actually isn't required to foresee it, how on earth is this third question good sense? You're asking whether the skilled reader nevertheless would have understood that that must mean at the date of priority.
Yes, or the date of publication of the patent. And what is significant is actually the way in which this matter was addressed, because we say it was rightly addressed in that case, as it has been here, by reference actually to the perceptions of the skilled person, both in terms of the question 2 and in terms of question 3. And your lordships see that by the analysis that was actually undertaken by the respective experts in that case of the question of whether or not the patentee intended to confine his claim to the primary meaning of the helical
Since
spring.
by definition the patentee need not, or the skilled person need not have foreseen this equivalent variant, by what standards do you judge whether by the wording or not they understood that the claim was confined to include or exclude it?
Well,
I mean, it seems an unreal question. By definition, one would have thought the patentee would say, well, now I see that this exists, and it's obviously doing the same thing. It's building on my inventiveness. It shouldn't be. Of course, I never contemplated that.
My lord, that is absolutely right, and it may be that looking at the issue from the perspective entirely of the patentee may be a slightly artificial way of looking at it.
But even objectively, it's an artificial way of looking at it, because you're dealing with language which probably by definition actually didn't contemplate this.
My lords, that's right, but the question that one has to address under this head is whether, to the relevant skill team, the features that were identified as being essential features were important features, technically, for one reason or another. And the evidence in relation to this case was that actually there was a significance, a real technical significance in the specificity of a helical spring, and that is a technical significance to which attention should be given in seeking to determine whether or not this was a material variant or an immaterial variant. And I don't want to take up time by going through all of that material, but your lordships can see the way in which that evidence was developed in that case. And if you turn on after the consideration of all of these matters to page 197, MS 2470.
Yep.
Passage in the middle of the page, thus interpreted, I do not think that helical spring can reasonably be given a wide generic instruction, and he accepted Dr. Laming's evidence in relation to that, and rejected the suggestion that merely because there was an equivalence clause, because many patents used to have equivalence clauses which would essentially expressly claim equivalence at the end. They'd say, I claim anything that's equivalent to what I've set out above. It was not
And technically,
appropriate.
in the first sentence, if one's going to be strictly accurate, the third line would be a skilled man would not have understood. Is that right? Standing as at the date of the priority date, yeah.
My lord is right.
It's a trivial point. But.
And finally, on improver,
Yep.
Just so that your lordships know what was going on in improver, because as you will have detected, the improver issue appears to have been a motivation for some people saying that there needed to be a degree of greater consistency. But one thing is significant about the improver case, which is often forgotten, which is that the Oberlandesgericht in Germany, on the interim injunction stage, took exactly the same view of the scope of claim as Lord Hoffmann took at the trial. It's true, ultimately, that the trial judge at first instance took a different view in Germany. But to say that there was this one-way approach in England and a completely different approach in Germany is wrong. And that is recorded on the next page, in 198, of Mr. Justice Hoffmann's judgment.
Yes.
And it's a passage that repays reading. He Well, perhaps I could just invite your lordship to read from the top down to the bottom of the quote.
So it's down at the bottom of the quote.
Yes.
Okay. Yeah. Thank you.
And so, my lords, the idea that there is this generic and generalized difference in approach between the UK, which is unduly strict, and Germany, which is unduly loose, is one that needs to be viewed with a great deal of caution. It is true that there are divergences of view in different cases at different levels of appeal, and your lordships have seen that in this case. The Landgericht held that there was infringement. The Oberlandesgericht, in a very long and detailed judgment, which I'll refer you, not in detail, but invite you to read, said no for a whole lot of reasons. The Bundesgerichtshof has said that they didn't agree with some of their reasons and sent the matter back for re-evaluation, and we await the result. We say we await it in relation to all of the questions again. But that's the position with Improver, and then of course Amgen comes into that frame, and we've looked at that at length already, and I just want to draw out 2 or 3 points very briefly. First of all, of course, this was a case after EPC 2000 and was purporting to take account of it. Secondly, although the approach was described as one of construction, your lordships have my submissions as to whether that is quite the right way of describing it in terms that will be understood by everyone, if I may put it like that. But it is an understandable description for the reasons that I have already gone into.
So how would you summarize the reason why the Oberlandesgericht came to a different conclusion from Mr. Justice?
Because they did two... Oh, the Oberlandesgericht...
The Landgericht, I think.
The Landgericht took a...
The Oberlandesgericht overruled the interlocutory injunction. It was the final decision was by the Landgericht.
Yes.
Yes, quite right.
Well, I don't have the full reports here, but from this report, one would say that the Oberlandesgericht took the claims and what was specifically claimed more seriously than the Landgericht, either at interim injunction stage or at final trial.
Yes, but the difference between the Landgericht and Mr. Justice Hoffman, how would you summarize that?
Well, I would summarize it in Mr. Justice Hoffman's words, because he actually did that.
I don't find them terribly clear, I have to say. But
he was critical of the Landgericht in Düsseldorf, in the passage I've just referred my lord to.
It's surely the fifth line of the page.
Exactly.
They didn't find it necessary to ask the third improver question at all. That's his view.
Exactly.
So they didn't treat it as a matter of construction or whatever at all. They just said, is this an equivalent? And if it had been known, would it have been realized to be an equivalent?
And that was, of course, before the Schneidmesser quintet and the express setting out of a 3-stage test, of which the 3rd stage in Germany does require, again, a consideration of the claims. Quite what that amounts to is not quite clear, but it certainly does amount to that.
Cutting the knot, was it? Where do we find the Schneidmesser?
well, it involves looking at the claims, but without reference to the principle expressio unius. You've got to find something more than simply the fact that the claim describes it in a way that doesn't include some feature of the infringing item.
That's one way of describing it. In our submission, that's not the only way, and I'll draw your lordship's attention to the academic commentary by Dr. Meyerbeck in relation to the test that he set out in due course. If I can come back just briefly to Amgen. Amgen, of course, seeks to incorporate equivalence, just as Catnick and Improver did, but to do so in a way that treats equivalence as built in to the question of construction in its broad sense, and your lordship see that from paragraphs 36 onwards. Amgen, I apologise, is at tab 7 of that bundle, MS 2505, and the doctrine of equivalence passage is at MS 2523. And the issue that sometimes divides commentators is Amgen says there is no separate doctrine of equivalence. What one ought to emphasize in that description is not there is no doctrine of equivalence, it is that there is no separate doctrine of equivalence. And your lordship see from those passages the way that equivalents are built into the approach. And it's true, that's not the approach that's taken in the US, where they deal with equivalence, where they deal with literal construction and they deal with equivalence separately, as do other courts. But this is a way of building it in. And Lord Hoffman not only takes account of equivalence, he expressly considers the question of whether there is consistency with the protocol, again, in paragraphs 45 to 48, and I commend those to you. It would be, in my submission, very regrettable if it were to be said after all these years that actually, as it turns out, what we've been doing is completely wrong and has never been consistent with the protocol in the first place. Equivalence as a guide to construction, the passages 49, paragraphs 49 to 52, equally suggest that equivalents are taken, what one might call due account of, by the approach in Amgen. It's very difficult to see why that isn't taking account of equivalence. And as your lordships have already seen, what Lord Hoffman does and the approach that has been applied with absolute consistency over the years in lower courts in this country and Court of Appeal is to take Amgen as the framework for determining scope of claim, applying where appropriate, but not with a rigidness, the improver questions in order to effect that. And in our respectful submission, that is an entirely appropriate thing to do. And part of the reason that it is appropriate is because it involves an ultimately unitary question that in appropriate cases is decided by a three-step test of a kind that is not that dissimilar ultimately to the three-step test in other jurisdictions. The difference may be much more of shade of emphasis than formulation, that we take the claims somewhat more seriously in the generality than some courts do, although even that is up for question, as one actually sees in the debates between the German courts in this very case and in the improver case. And if one wanted to do a sort of statistical analysis of the seriousness with which limitations in a claim are taken, one probably could do that exercise. I would not venture to bet the ranch that we would end up doing worse in terms of specificity that we give to the claims than any other jurisdiction in the world for different reasons. And the idea that we are sort of out of line as a result of applying the test that we apply is, with respect, simply not substantiable. And so we would respectfully commend this approach to you. And if I can then turn to why we say it's not just us saying that, it is also other countries who don't have any difficulty with our applying and indeed continuing to apply Amgen. To the contrary, they draw inspiration from the tests that have there been established. And the more sophisticated jurists who look at this matter in detail, as I've indicated, actually perfectly well understand the two senses in which the term construction can be used, and perfectly understand that Amgen is giving effect to taking due account of equivalence. So can I now invite some attention to Authority Bundle 5. This is a large bundle, and I don't want to spend undue time on it, but I just want to draw your Lordship's attention to some of the more interesting decisions that you may want to look at, partly because of the nature and quality of the analysis, and indeed the comparative analysis, and partly because of the approach and result that you see. And the first set of decisions I'd invite your attention to is Switzerland, which is another EPC country. And one of the reasons for going to Switzerland first is that no one could say that Switzerland was a country which didn't have a vibrant, research-based pharmaceutical industry, where one would imagine that that was something that was, in a sense, part of the judicial knowledge and framework, and the idea that adopting an approach to construction that actually gives effect to the language that's used in the claims, even in the case of a pharmaceutical patent, you might have thought was if any jurisdiction is to be looked at where you think, well, actually, this is one which might want to take an expansive view for particular reasons, this is it. Switzerland does not do so. If you go to tab 23 of Bundle 5, MS 4935, you have two decisions there.
Yes.
One, and the advantage of these decisions is that they're decisions in this case, in the sense that they are the same patent and the same subject matter. The first decision is an interim injunction decision. The second decision is the final decision on a declaration for non-infringement of a kind very similar to this case. And the matters that I want to draw your Lordship's attention to first are, and we can take it from tab 23, so MS 4940.
Thank you.
Where they deal with the question of first literal infringement and then equivalent infringement. And you see what might be said to be a two-step test, but in a sense a two-step test of exactly the same kind that we apply, namely look at literal and then look at equivalent by reference in turn to a three-step test. Three-step test there established by the Dross-Pyre-Renane decision in the Swiss court. You see the three tests under paragraph 4.5.2, and they approached on the matter of an equivalent effect. Are the replaced features obvious? And based on the wording of the claim, in the light of the description, would a person skilled in the art have considered the replaced features as a solution of equal value? And say that they apply that test. They also take into account the prosecution history, and you see that in paragraph 4.5.3 on the next page, MS 4941, and they consider the effect of the prosecution history on the next page, and the passage that I don't invite you to read now, but which you may wish to flag for future reading, starts for the assessment of the significance of, in the middle of MS 4942, and down over to MS 4943, where they analyze the decision HG060066 from the Commercial Court of Zurich, which gives effect to the prosecution history. And they then apply that to this case, and start off by considering the prosecution history. And you see that the application to this case starting at MS 4943, and it's clear from the prosecution history that there was an exclusion, and they deal with that over to MS 4944, and then they deal with equivalent effect in paragraph 461, and the important point that they reach is twofold. First of all, they reach the same conclusion in relation to the first test. They reach a different conclusion in relation to the second test from that in the UK and the Court of Appeal. But critically, they reach exactly the same result as Mr. Justice Arnold and the Court of Appeal reached in relation to their third test, namely that of equal value. And you see that on page MS 4946, and I would invite you to read the equal value section over to MS 4948.
You'd like us to do that now?
You could do it now.
If you'd like us to now, we'll do it. If it can do it later, that's fine. Which would suit you?
It doesn't matter. Let me make a few just short points on it. First of all, equal value is determined based on the wording of the claim. And that's the first paragraph of that decision. And they go on to say that the person skilled in the art, in the middle of MS 4947, would certainly have recognized that with pemetrexid disodium, in contrast to the other components of the claim, a specific single substance was being required as a component of the drug, but therefore have assumed that the limitation was not without reason, and they hold that it's consistent with the Court of Appeal and indeed with reasoning of the German court in relation to its decision on occlusion device, but they decline to follow the approach of the Bundesgerichtshof in relation to their third equivalence question, because the Bundesgerichtshof, they say, focuses to a great extent on the question of waiver, an express waiver, and that's their criticism of the Bundesgerichtshof, an issue that we say may yet be resolved in our favour, ultimately in Germany. But it can't be suggested that the Swiss court there is saying, well, we have got to follow what the Bundesgerichtshof has done in relation to their approach. No, we will take our own view in relation to that. On the declaration...
It's basically answering question 3 by treating the specificity of the description as a sufficient exclusion
Indeed.
of every other description. And that essentially, I mean, there's a circularity about that. It essentially limits equivalence by reference to the literal language, so that one might goes say back to their starting point at question 1.
One might say, and what's wrong with that? Where a skilled person would recognise that there were good reasons for doing so. And the reason I say that is
well,
this.
Where do we? I mean, the skilled person in the middle of 4947 would have assumed that a single specific substance was being required as a component of the drugs. He would therefore have assumed that such a limitation was not without reason. So essentially the court isn't saying, well, that the hypothetical assumed person would have appreciated the following scientific reasons why the limitation was a sensible one. What they're saying is, because it's specific, one's got to assume, without necessarily inquiring any further, that they had a good reason for doing so.
Well,
so one just goes back to the language.
As it were, on the facts of this case,
yeah.
that was the assumption or the approach that the Swiss court took, and we would say a reasonable assumption.
But it's a purely linguistic test, isn't it? Because the assumption is made on the basis of the specificity of the language.
In one view, of course, my lord is right, but one might say, well, that is sometimes what words do. They actually do mean what they say. And the Swiss court was doing no more in this context than saying, well, the skilled person would have good reason for assuming that these words meant what they said.
No, they're not saying that. They're saying the skilled person would have assumed that the patentee had a good reason for limiting it in that way.
Indeed. I don't think there's a difference.
The skilled person on this analysis wouldn't have entered into the question whether there was such a reason or whether it was a good one at all.
No.
Simply have said the language shows that importance was being attached to this.
Indeed. But that is important because what is being said is that, as it were, objectively speaking, from the perspective of the skilled person, it would have been recognised that this was not only specific wording, but it also was specific wording with reason.
But they don't say what the reason was.
They don't seem to care what the reason was, so long as they just are saying they must have had some reason for being that specific, and we don't need to inquire what that reason is.
Well, let's continue with the
We shouldn't take too much time on this. I entirely see why you rely on it.
with the decision. May I just then refer you to the decision, which is somewhat more complete?
Of course, 23A.
23A.
Yes, of course.
Where where Lilly says we want a different or larger tribunal because we want to review the equivalency questions. Equal value they address at 4.6.3 MS 4949U.
Yes.
And essentially, they address that in a similar way to the manner in which they addressed it previously. What they say, though, on 4949V is that there was a willing limitation to the disodium form, although other salt forms were known. There are no references to other suitable pemetrexid forms. The fact this was not done for pemetrexid would be attributed some significance by the person skilled in the art, because otherwise there would be no basis in the wording of the claim in the light of the description. And the person skilled in the art would therefore not consider free acid or another form of the alternative formulations as a replacement of equal value. And so it's not that they're giving no reasons for their conclusion. To the contrary, they are explaining by reference to what is actually the language before them and the specification as a whole, why they reach the conclusion that they do. But my point in relation to that is not even so much that they reached the same decision as the court here, although it is interesting that they did, but it is not possible to say, and indeed my Lord Sumption's observation in a sense highlights, that other European countries say, well, we are not going to give effect to the what we assume the patentee must have intended by the use of the language that they chose, the specific language that they chose in their claims.
It might be said that on that basis, what was Lord Hoffman doing as Mr. Justice Hoffman going into improver questions? The person had claimed a helical spring and a story.
My Lord, that picks up on a point that my Lord made yesterday, which is, well, can one sometimes go direct to the answer, as it were, by looking at question 3? And the answer is, in some cases, yes, one can. One might look at it in this way. There are some cases where it may be pointless to look at questions 1 and 2. And the reason it may be pointless to do so is because there's such a clear answer to question 3 that actually going into questions 1 and 2 doesn't really advance matters.
Linguistically, improver was such a case.
Indeed.
So essentially you are saying that Mr. Justice Hoffman was basically going through the other questions just for the joy of it.
Well, that is, if I may say so, slightly too... the reason that I just hesitate before accepting that
It's a tendentious way of putting it.
It is, but not an entirely unfair way, if I may say so. Is because if one's thinking about orienting oneself from in the perspective of the skilled person and considering questions of what would be obvious and the way the invention works and so forth for the purposes of question 2, one is essentially doing some of the work that one needs, or the groundwork that one needs, in order to answer question 3. So it's not forensically the case that this is a completely sterile exercise.
Question 3 only makes sense in the context of the other 2 questions if what it means is that you go back to the language at the end and say, is the language such that the draftsman is effectively saying, and I really mean only pemetrexid disodium. There's got to be something other than the mere use of the term pemetrexid disodium, which indicates that it is intended to be applied strictly.
My lord, in a way, your lordship is absolutely right. And the "do I really mean it" is actually sometimes supplied by the perspective that is brought to bear by the skilled team. And one sees that, with Catnick as quite a good example, because it might be said that the skilled person in Catnick would say, do they really mean vertical? Do they mean vertical? Or do they mean sort of vertical? And, which is an adaptation of my Lord's question, do they really mean it? Now, if the answer to that is from the perspective of the relevant skilled team, it would be appreciated that there were good reasons for really meaning it. Then that is of relevance in answering the improver question.
There were reasons known to the skilled team and therefore capable of explanation by the judge, rather than simply an assumption that there must be some good reasons lurking around somewhere.
Exactly, and the part of the reason that I say this is because, of course, patent scope has got to be an objective question. And if that's right, then one is in territory where one is supposed to align the assumption of the skilled team with what it is assumed that the patentee was trying to achieve.
Yes.
Germany, I've already referred to, and I'll perhaps come back to that briefly. Netherlands is the next jurisdiction that is worth looking at. And again, if I can take this relatively briskly, just to invite...
Try and let you do that.
My Lord, I hope I haven't been wearying you with...
On the contrary, maybe our interest in the topic is an engaging style. We have been putting a lot of questions.
No problem. I certainly welcome them. Tab 13 is the next useful document that I would invite your attention to in Bundle 5. It starts at MS 4650.
4650, thank you.
And let me just tell your Lordship what this is. This is the opinion of the Advocate General to the Supreme Court, Mr. Van Persen, who I mentioned previously, in a case called Beyer and Sandoz, of which you have the ultimate decision of the Supreme Court at the next tab 14.
Right.
It's a little bit like European jurisprudence, where the Advocate General's analysis and comparative survey is of greater breadth than the ultimate disposition
more easily understandable
of the Supreme Court, and sometimes more easy to understand. The Supreme Court essentially agrees with the Advocate General, although it doesn't expressly say, I adopt all of his reasoning.
Understand.
Now, the reason for referring, my Lord, to this is because it contains one of the more magisterial, to use a term that's used quite frequently, surveys of the state of play with respect to equivalence in Europe and abroad. And partly because of its length, I'm not going to invite your lordships to read it now, but I'm going to make I'm going to draw attention to a few selected highlights and then draw some
Are you polite to
general
we could
points.
beneficially read the whole thing?
You would certainly, well, that's presumptuous. May I submit that it would be beneficial
You may submit.
to read the whole thing.
But you're going to give us the bullet points.
I'll give you some bullet points, first of all. So let's start with page MS 4668, scope of protection. where Mr. Van Persen starts with an account of Article 69, and in particular, if you turn over to page 4670, he deals with the revision in 2000 and the commentary that the clarity that was desired under the difficult topic of equivalence had not actually been provided by the revision of the EPC 2000 as a result of the inclusion, and makes the point that while due account should be taken of equivalence, it does not provide any leads on how to define such equivalence, nor precisely how to take these into account. For existence by means of a specific test, such as the function-way result test, which originated in America, is often employed in the Netherlands, or the insubstantial differences test, or in some other manner, such as immediately considering equivalence during the initial interpretation of the extent of protection, compare the purposive construction in England and Wales after the Kirin-Amjin ruling by the House of Lords, all to be returned to below. But of significance there, he is not suggesting there, nor does he suggest anywhere, that the approach that we use for taking account of equivalence is not one of the ways in which due account is taken of those equivalents. Next point, paragraph 2.8 on the next page, MS 4671.
Yep.
And he says there, and this will sound familiar, before sketching the interpretation and equivalence approaches in the United States, Germany, England, and France, I would like to recall this ultimately concerns the interpretation of legal texts with a view to borderline cases. This is any lawyer's core business. The writings of Advocate General Heudekoper on this matter, in his opinion for Arga and Oklitek, are well worth reading. That's in the Supreme Court of the Netherlands as well. Same goes for Lord Hoffman's leading speech. Dr. Heudebecker provides a number of examples of situations that may give cause for broader or stricter interpretation to be applied, and arrives at the conclusion that there is no uniform way to interpret patents. Each patent must be interpreted within the context of the circumstances prior to such patent. According to him, the doctrine which is being developed on the basis of Article 69 acknowledges this varied reality, and I fully agree with this nuanced approach. Now, in my respectful submission, that is not just me saying it, because that is essentially not let a thousand flowers bloom here, because we're not quite in that territory of diversity. The point is more that an element of diversity with the same result is acknowledged, and it provides some support for my proposition.
What does it actually mean? What does it mean? Each patent must be interpreted within the context of the circumstances proprietary to such patent.
Specific to such a patent, I think he must mean. There may be a translation issue.
Yes, but I mean, does that have something to do with the legal system which is applicable to the patent, or what does he mean?
No, as I would submit, that means with reference to the particular patent. And what he is trying to get at is that different patents will have different degrees of specificity to them and different inventions, and what one can't do necessarily is provide an absolutely 100% copper-bottomed, applicable across the board test to every field of invention, because each patent will require a degree of specificity. Now, that, of course, is unattractive to those who are concerned with harmonization of law and so on, because they might say, well, there should be an absolutely common approach.
But this isn't to do with harmonization of law. It's to do with the fact that different patents, different types of patent, require different approaches. And because you're looking through the eyes of the national skilled addressee, your point about perpendicular, a laser compared with Catnick is an example. And chemical patents also involve different problems from mechanical patents. Is that the sort of thing?
My Lord, that's exactly right.
Yeah.
The next point, and again, if I can just draw your Lordship's attention to the way that he does it, is he then starts on his survey of US law and law of other countries. On US law, again, this repays study. Yeah. There is a risk in taking over US concepts directly. And I just want to draw your Lordship's attention to those, and he draws attention as well. In US law, because they have this two-step approach, literal construction and then limitations from the file and other limitations.
Is that file wrapper estoppel?
File wrapper estoppel.
Yes.
And there are cases in the bundle relating to file wrapper estoppel there, which I'm not going to take you to because it's a different system. But one thing one's got to be very careful about, and America is an illustrative example, is taking an element out of a foreign law system.
Exactly.
And saying, oh, that looks good, without recognizing that there's another counterbalancing element that one hasn't looked at in that foreign law's legal system. So there's one issue that was debated in foreign courts, for example, which is when you look at an alleged infringement, an issue that's sort of
That's
here.
a very well-made point.
And one of the underlying questions there is, there's some people who say, well, the American courts at one point moved to a situation where if you could in principle have foreseen the variant, but you didn't claim it, it's out.
Right.
It is essentially a public policy anti-evasion rule in the States.
My Lord, yes. It is that, but one has to be a little bit careful with that, because if your Lordship looks at Phillips, which is a leading case in the Court of Appeal for the Federal Circuit in the United States, which is the highest level to which the fundamental questions of construction of patents have gone. They've been dealt with in other ways by the Supreme Court, and that is in the bundles. What you will find is that the prosecution history is taken into account as a question of construction and is regarded as intrinsic evidence of construction.
As with the approach of most American states to contracts.
Indeed.
I mean-
and that's why one does need to be a little bit careful here.
Do we do better to ignore US cases then? Or would you, once you start learning things, you run into the very difficulty you've articulated so well a minute ago?
The only thing that I would invite your Lordship to draw from the US cases, which comes on to the further point that I'll make shortly, is there shouldn't be a fundamental resistance to relying on the file because it's very complicated and so on.
Was there a proposal to get rid of file wrapper estoppel in the United States that came to nothing? Or not?
My Lord, I'm
Perhaps I should-
sure there have been proposals.
Perhaps, don't waste time.
I have to say I can't give you a clear answer.
We're interrupting you enough as it is, don't worry.
There is actually, just if you're interested, there is a very good decision of the US law on file wrapper estoppel in the English case of Celtec and Medimune, which you will find in the bundles,
Thank you.
which in some respects is clearer than some of the American textbooks,
That's
at least
helpful,
in relation
thank
to this. Let me then press on this. Schneidmesser. Now, again, Dr. van Persen sets out the Schneidmesser approach.
This is 4675,
4675,
yes.
Yep. And he sets out the test, and you can take it from there or elsewhere. But there's one point that you really want to think about, or you may want to think about, which is on the next page, MS 4677. Now, one thing that he does is he analyzes the question of Gleichwertigkeit, equal value, which is the third question. And my lords will read that test for yourself, and you can read what Dr. Meyer-Becker said about it as well. But I suspect that you may develop a sense, as you read that, of not quite knowing where it is pointing ultimately. And that is a point to which Dr. van Persen draws attention. And he says at the conclusion that he does not regret that the Netherlands does not explicitly apply these complicated Schneidmesser questions in the Netherlands, and he would not advocate their application either. So far from a jurisdiction here saying, oh, well, we should be following Germany because they have they have been maßgebend, to use the term of the cases in this respect. He is saying no, that shouldn't be done. And in fact, we say that when your Lordship is thinking about harmonisation, that's something you want to bear in mind. Then he does England, and obviously you can skip over that. But the key question, or the key issue in relation to the UK is that he does not at any point suggest that the UK is out of line or is in some way doing something that is fundamentally erroneous in principle. To the contrary, he notes that the function of equivalence has been effectively subsumed by purposive construction, and he considers that the English approach, which recently has been restrictive in relation to prosecution history, is somewhat out of line with the rest of Europe. And again, our submission there is that we don't have, what is significant is what this document does not say, which is, you're doing it wrong, please change. There is another passage which you do need to think about a little bit, which is this, because there are shades of it in Lilly's case, which are trying to take different bits from different legal systems and bolt them all onto each other. And one of them is to say, well, okay, what we're going to do is we're going to do a purposive construction of claims, first of all, and then we're going to add equivalence on. To which Dr. Van Persen says, well, that's double counting.
I see that.
Effectively. And you see that on 4689, and you also see his analysis in France and then in the Netherlands. And our take-home, or the take-home that we invite you to take in relation to this, is a recognition of a degree of diversity, a recognition of an appropriateness of giving due cause to equivalence in different ways, and a recognition that complete harmonization of the approach is not something that is actually necessary at this point. We would commend that approach to you. Finally, on this, and you'll obviously see some of the other comparative law in the specific aspects on the specific jurisdictions that are in issue, albeit I hope very, very briefly. It's worth just bearing in mind that the other common law jurisdiction in Europe, Ireland, has taken up Amgen without difficulty, and you see that in tab 22.
Thank you.
Which is an illustration of its application in Ranbaxy and Waller-Lambert by the High Court, Mr. Justice Clark, and he goes through the principles of construction and the protocol questions, and those are applied in that context. And he says in paragraph 3.25 on MS 4924, there's no magical difference in the proper approach to the construction of a patent on the one hand or any other document intended to give effect to legal obligations on another. And in that case, he finds that the patent is clearly infringed.
If that's right, sorry to bang on about this, but coming back to Improver, or this case, if the construction of documents is no different, then forget this is a patent. The Improver case, the Epilady case, again, it's obvious. Of course, a rubber component isn't included.
Yes. Perhaps I was too brisk on that, because what he draws attention to is that you have to look at it through the eyes of the, as it were, addressee, the relevant addressee of the document.
I see.
And he says that's what's going on in Improver. There isn't a fundamental difference, so long as you take the correct perspective at the outset.
Thank you.
So that's where we are on the comparative law. And our submission is, well, I've made my points really in the course of answering your questions. I think you have that point. But what we would say is that there is no jurisdiction which really has what might be called only a two-step test for implementing an approach to equivalence, which simply asks, is the alleged variant equivalent? All of them operate by some level of control at either at an initial stage or at a final stage on the scope of things that are actually to be regarded as within the scope of the claim. And they do so in slightly different ways, but often with exactly the same result. And so that is a very long way.
Surely the German control is completely different. Gleichwertigkeit is a valuation of the difference, if there is any, and in the present case, your opponents would say, well, there's no added value, it's just a way round.
Yes, the difficulty is with that proposition that, first of all, the German courts have not regarded themselves as being significantly different from the UK, and you can see that in the way that they deal with the law. Secondly, if there is a difference, there's always a difficulty in working out who is out of line with this, but
that would be your submission.
We would respectfully submit that our primary submission is no one's out of line, but there's no reason why we're out of line with the common group. We're not. We're squarely within the common group in giving effect to the language of the
The
claims.
two jurisdictions we look at most in Europe would be Germany and the Netherlands. Is that true?
That you look at most.
Would be Germany and the Netherlands. Would that be true? Or do we look at others as well? I mean, in practice,
we look at quite a wide range. The Netherlands we look at actually partly because their judiciary is very engaged and they write rather useful surveys of the kind that you've seen. Germany obviously is very important economically and a very long patent tradition. Switzerland actually is rather an important jurisdiction, and it's not an accident that Swiss claims are called Swiss claims.
No.
They are because they originated in the way that the Swiss Patent Office
And
formulated claims in that context.
Yes,
French law tends to be slightly less referred to, but is in some contexts. Italian law equally, Spanish law to some extent. In some cases, Danes are quite important. I don't want to leave anyone out of a ecumenical European survey.
The fact you don't mention somebody doesn't mean we don't.
No. Expressio varius, etc. Anyway, the position there we would submit is clear. So before we look at the travaux, which my learned friend will address, there's just one other set of documents which you might want to look at, which is the academic materials, partly because they were referred to yesterday.
And partly because you've lost your copy.
And partly because I've lost my copy.
Now I'll find I have two.
No, I have my copy. And again, this is really just a direction for future reading.
Bundle 4.
Bundle 4.
Authorities 4. Yep. We've been taken to a
You've
couple.
been taken to Mr. Justice Laddie, and
Yes.
My submission in relation to Mr. Justice Laddie's article is I can certainly see where he is coming from in relation to the point on construction. But if you understand the approach that I've explained, actually the divergence is not a serious divergence.
You say his quarrel is really, his complaint really is calling it construction.
Indeed.
Yep.
And it's, one thing that's quite significant is that he doesn't really draw attention to any situations where there would be big problems in practice, in actual cases being decided differently. And of course, if my lord looks at actually what Mr. Justice Laddie did in practice, when he was deciding cases of which there are examples in the bundle, you see perfectly a large number of cases, both before and after Amgen, where he said, well, I'm going to give effect to the wording that the patentees have claimed. Brugger and Medicaid is a good example in a passage approved by the Court of Appeal in Sarah Lee, which is in the bundles. The paradigm case might be Merck and Generics, where Mr. Justice Laddie emphasized that effect should be given to limit the claims to what they had specifically claimed. And your lordships find that in Authorities 3.2, tab 24, right. Where, as it were, the true effect of limitation is actually revealed in practice. And no one suggests that he was wrong or that he was sort of straining at the bit to reach a different result in that case. To the contrary, this is a case where one sees the implementation of that principle. Similarly, Dr. Fisher, who came from Bristol to UCL to work with Mr. Justice Laddie, ultimately, although he is a little bit gloomy at the end, if you read the article as a whole, it's really not fair. It's not fair to say that the United Kingdom currently has its fingers firmly in its ears. No, 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 I can't hear you, which is why he ends the article. Where he ends the article. It's a kind of moan of inadequate attention that the English judiciary is paying. And for the reasons that I have drawn your lordship's attention to, it's actually not a justified moan.
Whereabouts is that?
That's
Right at the end of the article, I'm sorry, my lords, authorities,
tab 6,
volume 4, tab 6.
page 4378.
4378.
Yeah.
The next article, which actually does again repay study, and the Dutch are doing well on this, if I may say so, is one by Dr. Kalden, the senior judge of the Court of Appeal in the Netherlands, which is a relatively recent article which refers inter alia to this case, at the next tab, tab 7, and she deals with interpretation and the approach to equivalence, and analyzes the Dutch law on equivalence in a similar way to that of Dr. Van Persen at MS 4384. She makes a number of quite valuable points in relation to the prosecution file at 4386, where she says that it will always be consulted by attorneys preparing a court case, and no sensible patent attorney will advise clients without consulting the file, and it doesn't make sense to subsequently neglect the information in court. And
it should always be consulted by, for example, a licensee or assignee of the patent.
Well, it probably would be in circumstances where, for example, let's take a licensee of a pharmaceutical patent where there was a question as to what protection was offered
Buying, yes.
against generics. One might say, well, we'd certainly better have a look at the file to see what we're buying here, to see what's been said about scope.
Well, I mean, I can quite see he might do that, but I mean, maybe one just doesn't know, but would you say that it would be a routine step to consult the file?
My lord, I think that probably is going outside the boundaries of what I can submit to my lord, because I don't have the evidence as to whether or not it is a matter of routine. What is said here, from the perspective at least of this judge, who may or may not have been in practice, is that it was routine. And
routine for litigation patent lawyers, which is, they are professional leavers of no stone unturned.
My lord, of course.
Can one say, it is a cheap point to say, is the proper question whether the national skilled reader would Mr. Lord Diplock's mathematically inspired builder?
You see, that is also a difficult question, because since Virgin, the notional reader of the patent is deemed to understand the law of divisionals.
I see.
Now,
therefore, he might or she might also.
If you're in the territory of understanding divisionals, in a way you can't understand divisionals without understanding what a file is. You can't understand what is being divided out of what, at least to some extent, without consulting the file. So as soon as you've got that in your mental framework, then you are in different territory. But my point is perhaps slightly better made, and I can do this now because I don't have to do it later. If you look at the way that the AIPPI has considered the extent to which prosecution files should be taken account of in the most recent materials, which is an international body, many lawyers, IP lawyers, and so forth. Actually, the suggestion is yes. Now, if there was a fundamental difficulty in taking this into account, one would have thought that AIPPI would have said no. That's actually in the supplemental bundle at tab 2, and it's entitled Use of Prosecution History in Post-Grant Patent Proceedings. But perhaps I'm running ahead of myself. on that point, just in answer to my Lord's question. On going back to Dr. Calden's paper, legal certainty, and she gives reasons for using the file in the context
Which
of
page are we on?
legal certainty. We're on page 4387.
Thank you. She was in practice.
And she analyses the decisions of the UK courts, finding the life's too short argument unconvincing. One doesn't have to read the file. No one forces anyone to do so. Practice has shown it's usually done, and it's very unsatisfactory if somebody has made the effort to go through the file. Court subsequently has to ignore it, and she actually comments on the Court of Appeal's decision in this case, and considers that on the next page that the Court of Appeal's approach is an artificial one, and it's quite an interesting passage. The passage starting with all due respect on MS 4338, second from the bottom.
She does seem to have been in practice before she became a judge.
Yes.
So,
With all due respect, it seems slightly artificial that the prosecution history, which shows that the claims are limited to the disadium salt following disclosure issues raised by the examiner, is first extensively discussed in the judgment, and the reference to it is not considered useful, and subsequently it's decided the claim should be construed narrowly. The skilled person would see the broader claims lack support and might have been objected to during prosecution. This is something that strongly reminds us of keeping up appearances. And one might say, well, there is something in that. She then deals with the German court, where, again, the Düsseldorf court rejected the prosecution file, but again then referred to it. There is a degree of ambiguity with which the courts around Europe have been dealing with this issue. And then finally, and I would just commend this to my lords as an indication of the less gloomy tradition, or the less gloomy approach with respect to harmonisation. At MS 4390, the last page, she says this: cases such as Arger, Oklitek and Medinol Abbott clearly show that European courts have come a long way from their own traditions. They may, to a certain extent, still struggle with their old habits, but that has not prevented the courts from coming to a largely harmonized approach that leads to the same end result. By avoiding both Scylla and Charybdis, they strike the right balance between fair protection to the patentee and reasonable legal certainty to third parties, and that is what claim construction is really about. And one might say, well, actually, that is not a bad summary of where we are at the moment. And it is consistent with the article by Dr. Meyer-Beck, obviously somewhat earlier, who sets out the approach in German law, which he says actually is following the English model, although he draws attention to some differences. It's actually consistent with the other academic articles, so tab 9, a long article by von Drachen, which you may want to read, but is perhaps less pithily expressed than some of the other material that I've shown your lordships. At the end of that article, page MS 4432, he says this: the divergence in acceptance of a doctrine of equivalence might appear to be merely due to a different understanding of the term, because the general concept behind it, expansion of patent scope by abstraction, is covered by the sub-rules of both England and Germany. To one closer examination, that divergence reveals a possibly larger problem, namely that sub-rules and principles are not much different anymore. However, the underlying rationales of determination of patent scope remain different. And in my respectful submission, while that is so, one might say, well, is there a reason then for greater harmonization of the sub-rules and harmonization of whom to whom? My lords will, of course, remember in Schutz and Verret, your lordships dealt with the very issue of harmonization in this context. Plainly, the English courts should, if possible, follow decisions of the enlarged Board of Appeal, but that is a unified court in this sense for the granting authority, which has representatives from I'm not sure all the contracting member states, but at least I think a very large number of different member states who can feed in their legal traditions into that context.
Has the enlarged board given a view on looking at the file?
No, there's no. There's no view. I mean, you might say this is the paradigm body of looking at the file, or not. But the other thing that my lords said in Schutz is that conversely there shouldn't be a pressure for us to follow the Bundesgerichtshof, although of course decisions of other courts of course jurisdiction, particularly higher courts, are to be afforded appropriate respect. So in a respectful submission, the pattern is pretty clear from that analysis. And if I could then just invite my lords to hear Mr. Raphael on the EPC 2000 Travaux, which is a sort of self-contained section. I will then wrap up in relation to the EPC impact on UK law, and that will really deal with most of the issues we need to deal with. And I'll then come back briefly to prosecution history and the foreign law points, probably after lunch.
Thank you, Mr. Alexander. Thank you. Mr. Raphael.
My Lords.
Then take your time.
My Lords, Lilly has suggested that the amendments made to the EPC in 2000 require a change to English law. That proposition is not supported by the Travaux. Mr. Mitchell took you through some, but not the key parts, and I'll try to be as brief as I may.
Thank you.
The relevant authorities are all cited in our case, and I won't take you through those if I may. The one...
Can you just give us the paragraph?
The relevant paragraph of our case is in footnote 16.
Footnote 16, thank you.
Page 15.
Thank you very much.
The one, essentially a practical observation I would make, is that if a proposed amendment is not adopted, whether that is of assistance depends on the context. Its withdrawal does not in itself mean there's been a positive consensus on the reverse proposition that what it contained is not the law. It may just have been withdrawn because it was intended the point should be left open. And indeed, to use words of Bingham's in Mullen, the final text may have commended itself to the parties precisely because of the latitude of interpretation it offered.
Thank you.
Well, then turning to the Travaux themselves, they're in authorities value.
Wait, which footnote? 16. 16, I'm
Yes,
sorry.
footnote 16 on page 15, my Lord.
On page 50.
Of your second.
Sorry.
Indeed, yes. I'm sorry, my case.
Yeah, that's a confusing thing, thank you.
Page 50. Doesn't seem to...
It's page MS32L on the
Yes, correct.
bundle. Yep, thank you.
I'm very much obliged.
Thank you.
Then, turn to the Travaux themselves. The context...
Sorry, where are the Travaux?
In Authorities Volume 2, my Lord.
Yep. Thank you.
The context, initially, is that the EPC authorities were merely putting together a proposal that was later to go to the diplomatic conference where the states would take decisions. And all the earlier discussions must be understood in that context. The only decisions taken by the Committee on Patent Law and the Administrative Council are, shall this go in the proposal for discussion? No more than that.
Yep.
The first relevant document is at tab 19, Electronic Bundle 2674, and Mr. Mitchell took you to it. The only points I make on it are...
2674.
Yes,
This is,
Electronic Bundle number,
What's the hard copy number in?
MS 2650, my Lord,
yes.
at tab 19.
This is the draft, yes.
And the only points which you've seen, the office says that there are differences and it proposes harmonisation, but it does not say the UK is out of line. That's a submission Mr. Mitchell made, but it finds no support
Yes, I see.
in the document. Secondly, the EPO's proposal is on the right-hand side,
Yep.
and the essence of it is not what it said, but the fact that it was prescriptive. And it is that fact which was rejected, because this was not adopted. There's also a draft article on prosecution history.
Thank you.
Lords, that led to the discussion in the Committee on Patent Law, which you'll find in tab 20.
Which we looked at a bit of here.
Indeed, MS 2655 EB 2679.
Yes.
And again, you've seen it, and I'll make some brief comments. As I said, the actual decision is merely that this should go into the basic proposal for later decision, whether yay or nay. Secondly, if one looks at the Office's comments at paragraph 229,
Yes.
the Office is not saying the UK is out of line. Mr. Mitchison suggested that there was some idea that the UK had been wrong on Epilady, and that was what this was all reacting to. Not so. All that is said, in fact, they rather like UK law. They say that they've discussed the Catnick test. They say that the third step had yet to meet worldwide recognition. So they're saying actually the first two steps have met worldwide recognition. And they say as the third step of Catnick Improver, it was widely felt to be a useful addition to the doctrine of equivalence. And then they just refer to the divergent ruling in Epilady. Their focus is harmonisation. There is no suggestion we are wrong. Then, my lords, moving on, you don't need to turn it up, but this leads to redrafted proposals, but there's no material change, and you find that in tab 21. And then that goes forward to the Administrative Council, and the discussion before them is in tab 22, MS 2663, EB 2687. Again, one can take this very briefly. Again, the only decision...
What's the MS number?
It's 2663, my lord.
Yep.
The only decision is that this goes into the basic proposal. The UK's stance, 95, is that they don't like the prescriptivity of the test. There's no consensus on the substantive law. Different delegations express various views in various directions. So there is nothing in the idea that these negotiations show the UK is thought to be out of line. Well, that then leads us forward to the diplomatic conference.
Yes.
It was in November 2000. There were various proposals put forward by the states. And if I may, I'm just going to summarise what each state said. You'll find proposals in tab 24 onwards. The French, at tab 24, disliked the prescriptive equivalence article. Essentially, it wasn't French law. On the other hand, they did like prosecution history. The Swedish, at tab 25, said this is all premature, this is too complicated, you can't prescriptively harmonise at this stage. At tab 26, that is also the approach of the EPI, that is the professional representative body for the EPO, who are an official organisation and are therefore part of the Travaux. And they say they like prosecution history, but they think it's too early to harmonise. The German proposal is at tab 28. They like the second prescriptive article on harmonisation, and they like prosecution history, but they don't like the attempt to insert the date of infringement as the date of assessment, which was at that point in the Office's first article. But the important proposal, because this is actually an international negotiation in which the UK has considerable weight, is before that at tab 27. And it is the UK proposal. And the vital thing about this is what the UK proposed was the text that was adopted. You see, this is at tab 27, EB 2719, MS 2695. The UK makes two proposals. First, it proposes that everything be withdrawn because it's premature. That's in A at the top of page 1. But second, it says, well, if that doesn't work, we propose a much less prescriptive text. They say that in B. If you turn on to page 3, you'll see the unprescriptive text they propose under Article 2 equivalence. That is the text that was agreed. But we then turn back to see why the UK says this. essentially in paragraphs 2 and 3, they make the point that Mr. Alexander has just made to you. There's been a good deal of harmonising progress. Judges don't operate in isolation. They choose the middle way. And then in paragraph 3, there's reference to the present equilibrium, and it is suggested that the EPO's proposal will upset that. The courts have until now been able to operate satisfactorily with the most general of guidance from the protocol. So the UK is saying, Catnick and Improver is right, nothing should upset it, and there's no major problems with divergences. Well, we then move on just briefly to paragraph 6, and the UK delegation explained their view on equivalence. Without going through all the detail on that, essentially they are saying Catnick and Improver are right. At paragraph 7, they oppose the date of infringement idea. There are some negative comments at paragraph 8 on prosecution history. Accept that, but that is simply the UK delegation's view in relation to something that was not adopted, and we'll see why it was not adopted in a moment. And then the final point is that the following, under 10 on page 3, the following wording is indicative of the less prescriptive approach that we think should be investigated. If it's agreed, we should move in this direction, and that leads to their less prescriptive wording. Well, the next stage was the diplomatic conference itself. Before we actually go to the conference, it's worth turning to tab 29. This is a document MRPLD 600. You'll find it at MS 2703 EB 2727. This is the compromise text that the UK, Germany and France put to the conference after there had been a stalemate. It is identical to the text the UK had in its proposal. Well, then we go on to the actual conference.
What page was that? Sorry.
I'm sorry.
It's my fault, Mr. Adams.
MS 2703 EB 2727.
Thank you.
And Lords, we then move to the conference proceedings themselves, which are tab 30, MS 2704 EB 2728. And they are reasonably lengthy, but we can take them, I hope, shortly, at least for the oral debate. Essentially, there is a long debate at 155 on page 74 of the internal pagination to 166 about whether the office's proposal is a good idea. There are lots of dissenters. Then you move on to paragraph 167. It's on page 77, MS 2708. A vote to just simply strike out the office's proposal and replace it with nothing fails, though it's very clear to achieve, very close to achieving a majority, but not quite. That is where you have stalemate. And then at 168, you see the introduction of the agreed compromise UK, Germany, France proposal, which I took you to, MR PLD 60. And the idea is that this will replace the whole of the office's proposal on equivalence. And so it replaces both bits. It replaces the office's initial paragraph, which had the date, and it also replaces the more detailed paragraph 2, which had the detailed ideas on equivalence. The German delegation introduces this at 169, dealing with 2.1. They say the main difference in the basic proposal was the absence of a conclusive definition of the term equivalence. That's the point. They are deliberately not putting in place a conclusive prescriptive definition, and they also explain that they don't like the date of infringement proposal, and so that is also cut out. We just have the very simple wording we end up with. There is some discussion about this. The Belgians don't like it in principle, but there is no suggestion that it has any other meaning than that which the Germans attributed to it. And then you get the decision at paragraph 172, internal pages 78, where it is adopted by 19-1. They then have to deal with the formality of knocking out the office's Article 2.2. They'd only actually formally been debating 2.1, and that job is picked up by the second member of the triad, the UK, and the UK delegation explains why the joint proposed amendment provided for the deletion of Article 2.2, and it's the same as the Germans. The crucial factor was it was not advisable to provide a statutory definition at present in view of the continuing discussion as to what was meant by equivalent means amongst the parties concerned. And then there's some debate, but we get the vote at 176. So it is clear beyond doubt that the idea that the introduction of Article 2 was intended to impose prescriptive harmonisation is wrong. It is also clear beyond doubt that it was adopted on the express basis and put forward by the UK on the basis that it was not going to change UK law. Lords, I can then deal with the draft Article 3 point briefly. This was dealt with very, very quickly. It's paragraph 177. As you've seen, there was a draft Article 3 proposing mandatory reliance on prosecution history, i.e. all the states would have to do it. The conference then considered it. The Danish delegation moved that it be deleted in its entirety, and that's it. There is no explanation expressly of why, but you can get the context when you move back to what the Danish have been saying about the whole package, paragraph 164 on page 76, and the Danes are in the camp of too early to regulate, let's leave matters open. That also applies, if you look at 166, to various other delegations. You see Spain, Netherlands, Ireland, Finland and Italy, and then one moves on to 178, and one sees those are the seconders, essentially, of the motion. And so the article is deleted, but not because anyone has said this deletion will substantively preclude prosecution history. It is left to national case law development. That indeed is obvious when one stands back, because if there had been an intention to shut out prosecution history, there would have been a contested debate and no agreement. There would have been objections from the countries already using prosecution history, which at that date included Sweden, Netherlands, Spain, France and Austria and others. There would have been objections from the countries whose own proposals to the conference positively supported prosecution history, like Germany and France, and there would have been objections from Sweden and the EPI and all the countries who'd said it's premature to regulate it. That didn't happen, which shows that the purpose of the deletion of the draft article was always understood to be simply that the parties didn't want to regulate the matter. It was left for development in the respective national case laws. And indeed, subsequently, none of the countries that use prosecution history have been remotely troubled by the deletion of draft Article 3. Instead, the movement has been towards a greater adoption of prosecution history, as we've seen in Italy. It's also the case in Germany, because you will, I hope, be aware that whereas the Germans have historically been reticent on prosecution history, there has been a break in that tradition in this very case, because the Oberlandesgericht did allow prosecution history, and the Bundesgerichtshof does not say that is inadmissible. It accepts it as a matter of principle, and the references to that are in our case. Likewise, just stepping back to the previous point, there's been no meaningful suggestion in any of the evidence or any of the case law of the other counterpart states that draft Article 2 radically changes the approach to equivalence. And the interpretation of the Travo which we commend to you has been, in fact, contrary to Lilly's submissions, widely adopted. Just to take you to some references, on both points, on Article 2 and Article 3, it's the view of the Court of Appeal of Barcelona in a case called Sinfer and Lilly. And for your note, that is Appendix 3, Part 3, Spain, Tab 3, MS 1762, second paragraph, MS 1765, second last paragraph. It's also the view that was taken by the ARPBI very shortly after, in 2002-2003. For your note, that is Authorities Volume 4, Tab 10, pages 4 to 6. It may be worth turning up one academic discussion to illustrate how well understood this all is, and that is in Authorities Volume 4, and it is a piece by Professor Paul Torremans and Justin Peeler of the University of Oxford, and it's at tab 4 in that Authorities volume.
Tab 4, which Authorities volume?
4, my lord.
Thank you.
And you see it, page MS 4311, EB 4280, paragraph 8.3.3.2. You see a discussion of
Page again?
MS 4311, my lord.
Oh, yes, I see, thank you, yes.
You see that
Oh, yes, we've seen that.
proposed Article 3, this is towards the bottom of the page,
Yes.
it was never enacted, leaving national courts to reach their own position regarding the relevance of the Patent Office file when construing a patent claim. Positions thus adopted have differed among states. It's also, for your note, the view that was taken by Advocate General Van Persen in Bayer and Sandoz, which Mr. Alexander took you to. If I could take you to that very briefly, we'll be putting away Authorities Volume 4 and picking up Authorities Volume 5. And we'll be turning to tab 13,
Oh, yes, yes.
where you've seen it, and he says lots of very wise things, and in particular he is sound on this point, and the page I'd like to refer you to is MS 4702, paragraph 3.26.
47 what? 02?
My lord, yes. And in this paragraph 3.26, he discusses the argument that the file is not mentioned in Article 69 of the protocol,
Yes,
and he says that's completely unconvincing. The fact that it's not mentioned in Article 69 does not, a contrario, mean that the granting file may play no part in deciding protection. And he refers to a decision of the Bundesgerichtshof in Kunstofferteil, where in a one-line sentence, it's actually quoted earlier in his opinion, in a one-line sentence, the Bundesgerichtshof said, as a material support for its conclusion that it did not have to take into account prosecution history, it had said that it referred to the rejection of the draft for Article 3, but he says he doesn't consider that to be a valid argument against the granting file. Lord, the position is, therefore, that what the deletion of draft Article 3 simply confirms is that it's left open for national case law development.
understood.
There is a question of European consistency to bear in mind. This court isn't required to take into account, and of course it will bear into account the needs of its own system. In other systems, it may be imperative to have prosecution history, especially if you have a wider concept of equivalence. But we do submit that the use of prosecution history in other European states is of assistance here in this court's development of its own law.
Thank you.
Lord, then the only other point to make is just a brief reference on the use of Travaux by Sir Hugh Laddie. And here we're again in...
So we're back to Sir Hugh.
We are,
At bundle 4,
indeed.
right?
I'm suggesting the present case at your side is an Angora cat practice case.
Lord, the patent is so clear that one does not need to go to prosecution history. If your lordships were against us on that, and there wasn't a possible reading of it which went against us, then it would be an absolutely clear Angora cat case, and contrary to any sensible policy of any patent system.
That doesn't involve anything particularly pejorative, that phrase, which I hadn't come across before. It just involves that the animal looks small and cuddly at the outset and larger later. Is that right?
It does. But there is a pejorative aspect in the essence of the conduct, because it would be destruction of the gatekeeping role of the office if a patentee were able to restrict himself in prosecution and then claim something wider by way of equivalence.
But it's not done of a suggestion that this is done deliberately. It's just happens because of the vicissitudes of getting the patent through.
Just on that, Professor Franzosi, from whom the phrase comes, is a great phrase maker, you may know that he was the inventor of the Italian torpedo.
Well, that's why it did ring a bell.
Yes.
I knew it was an Italian patent lawyer, and I didn't know his name. Yes.
He was our expert in this case.
Oh, I see. I didn't know that.
Yes, indeed.
Anyway, Professor Laddie, where do we go to in his article?
Very briefly, there was an attempt by Mr. Mitchison to pick up on a discussion of legislative history
Yes.
and suggest that somehow there was something in that could affect the interpretation of the EPC originally. Now, that wasn't in Lilly's case, and so no one brought along the Travo, but we can deal with it quite quickly. It's
Right.
in tab 5
Yes.
towards the end of the article, paragraphs 71 onwards.
Right. 4342, right?
That's right.
Thank you.
In other words, just standing back, of course, there has to be some caution in the use of Travo and a priori material outside the Travo that precede an international convention.
Yep.
In the decades running up to the conclusion of the EPC, many people expressed many views on what they wanted. The two documents that Sir Hugh actually refers to is firstly the Morph report at paragraph 73. He suggested that was a good guide. That is a document from 1952. And the second document he referred to was a Hurtle study at paragraph 76. That is a document from 1960. Both of them were part of what he refers to as the background to the ICC proposal.
Yes.
But at paragraph 78, you see the ICC proposal was not adopted.
Yes.
So these are just some essentially German views long before the EPC, which were not adopted. And to have relied on these as proper Travo, what would have been required is to take you to the Travo and show the passage in the Travo, the actual Travo, which says this is what we intended.
Yep.
And instead, that's not what happened. What we are left with is the wording of the protocol.
Thank you.
Lords, those were my suggestions on Travo. Unless I can add further.
Thank you, Mr. Raphael. That's very helpful. Mr. Alexander.
Which is a convenient segue to the next topic, prosecution history. Now, just a few points to remind you of, first of all. As I indicated yesterday, there's material in the bundles showing the nature and accessibility of the file. And I will just draw your attention to that briefly so that you know what we're dealing with when we're dealing with a potential file in relation to the difficulty argument.
Yep.
It's Authorities, Volume 2, Tab 12.
Yes.
Which is the implementing regulations to the EPC. And if I could just invite your attention to the second page, that's MS 2624.
Yes.
And that has a section of sections on information to the public. The Rule 95 is quite important on MS 2627, communication of information contained in the files. That indicates that information will be communicated in the files. They can be inspected free of charge on the European Patent Register. Now, clearly, your lordships know, but it's perhaps worth reminding those who are not quite so familiar with application procedure, is that one puts in an application and the office will then object, potentially on multiple grounds, if they see reasons why the application is not in conformity with the requirements of the convention.
Yes.
It's very common, of course, for people to try and get away with the most they can get away with, just as in any application to an administrative authority. There is an absolute right, at least to make one amendment, and that's provided under Article 123 of the EPC, and that's in Authorities Tab 1. I don't think we need to take it up. And these are amendments that are made by the applicant and described in the legislation as of his own volition. So this is not necessarily amendments that are forced upon the applicant.
Well, what was the reference?
The reference is Article 123, MS 2369 and that's in Authorities 1, Tab 1. And the file that I showed your Lordship, or the extracts from the file that I showed your Lordship, are exemplars of that practice, partly, of course, because patentees always want as much as they can get away with, and as quickly as they can get away with it. And the role of the Patent Office is to ensure conformity with the requirements of the Convention. And your Lordships will probably know that when one is dealing with patent examiners, that they're not simply qualified in patent law, they are technically qualified in the field of technology in question, and they will be examining the application with technical knowledge and technical skill, which is why the patent attorneys, as you've seen here, make technical submissions to them. And you will recall the submissions, for example, made in relation to the vitamin B12 analogues, where the patent attorney said, well, because these are well known, you can have a wider class, and that the limitations were made in that way. Our submission in relation to what the English law should be is rather simple. We submit that you should not introduce, effectively for the first time, an absolute bar on reference to material from the file. That would be a novelty in English law. In Roman Haas, which you have seen, but is perhaps worth turning up, it's an Authorities Volume 1.
It's the last bundle one, isn't it?
Tab. It's the final tab.
Yeah.
Tab 8. At MS2556, the Court of Appeal there did an analysis of the English authorities on the point, and concluded that there wasn't any binding authority, that Netherlands contained a helpful statement of principle, and your Lordships have seen the material relating to the Netherlands, and regarded that as of persuasive value. And paragraph 42, I'd perhaps invite your Lordships to read on the bottom of page MS2556. A similar view was taken in the Arga and Occlutech case. It may not be necessary for you to turn that up, but I'll just give you the reference to that. That is Authorities Bundle 3.2, tab 28, and the reference is 3632. And on to 3634. Ultimately, that was not pursued because the reliance on the file was disavowed. But there was no suggestion in the Court of Appeal in that case that the approach taken in the Roman Haas case was wrong. In BMS and Norton, which was referred to in Roman Haas, there is additional reference to an earlier case, Fur and Trueline, where actually the file was relied on, albeit at an interlocutory stage. And we have that in the bundles as well, if you are interested, in Mr. Justice Jacobs' judgment, which is Authorities 3.1, tab 10. You see him outlining some advantages and disadvantages in the BMS case. The page is MS2980.
Thank you.
In the written
I see, he deals with that in paragraph.
relevance of file history. And he says that all the matters are to be considered perhaps by an enlarged Board of Appeal, or if current proposals were to proceed by a European Patent Court. Fortunately, he didn't have to consider them here. One point that he observes is this, that it would be unfair on the public if material they would not normally look at could serve as the basis for supporting a wide construction of the claim, but there's not the same sort of unfairness if a patentee, having contended for a narrow construction of his claim during prosecution, is held to that construction later, and that is the fur and true line point where that happened. On the Angora cat practice, just for those perhaps again less familiar with the terminology here, that there are two aspects of that practice. One is obtaining the patent on the basis that it's just a teensy-weensy thing, it's not going to affect anyone very much, or we are specifically restricting in this way, and then once granted, saying, well, these limitations that we had there, let's forget it, because we're going to use a number of doctrines to try and expand from what we originally obtained. And in fact, one sees this in two respects in this case. First, in relation to the alleged equivalence test, and also in relation to the alleged approach to Swiss claim. So they say, well, we got this Swiss claim on this basis, that it was a manufacturing claim. We had to comply with the law relating to that, because that was the position at that time.
It does beg the whole question, doesn't it?
It does.
I mean, if you're entitled to do that, if you're entitled to get a narrow, defined patent, and the doctrine of equivalence has any meaning, then you're entitled to take advantage of it. And it can't be pejoratively described, or however amusingly.
My lord is absolutely right, and but by and large, if I put it like this, Angora cat practices have been pejoratively described, and there is a good sound principled reason for this. If one thinks of a patent, it's not like a contract between private parties. Effectively, and all of these analogies are imperfect, it is a little bit like, in terms of what it forbids, a bit of secondary legislation which is allowed through by the office on certain conditions, and sets out in its claims what is proscribed by its terms. And one might say that there is a good reason, if one is in that kind of relationship, to use a neutral term, with an authority that is granting a right, to say, well, if the right is granted on a particular basis, then it shouldn't afterwards be open to the person who obtained the right on that particular basis to come along and say, well, actually, we're entitled to much more when they had specifically restricted themselves in that way. Now, of course, in some respects, all of these arguments are circular or self-supporting and so forth, but there is a principled reason here for an asymmetry in that case. So our submission is that there are good reasons for permitting reference to the file. It is sometimes helpful. It's a representation not only to the granting office but also to the world at large as to what the patentee regards as excluded from the monopoly. So there is a public as well as a private interest in this. The file is not really a record of negotiation as such.
Can you help us a bit on this? You're asking us to lay down effectively a principle here. It's very seductive to say there are 4 shortish letters here, and that's all. How typical is that of the file?
Well, again, there's no evidence in relation to typical.
Well, I know, but you've seen.
But our submission
the risk
is
of asking the risk of asking you to give evidence.
No, our submission is that it is typical of the relevant extracts of the file for these purposes.
Well,
and
yes,
I say this.
Relevant. That immediately begs the question, because one of the arguments in relation to negotiation not being admitted in relation to construing contracts, and one of the arguments against Pepper and Hart, is that, yes, there may be some relevant material if you admit it, but there's a very, very considerable amount of irrelevant material which may arguably be said to be relevant.
Yes.
And therefore there's a lot of digging needed in some cases, and B, a lot of argument still as to not what it means, but whether it even helps.
Yes, when I say relevant, I wasn't meaning it in quite that sense.
Right.
I was meaning in contradistinction to, for example, multiple copies of the Druck exemplar of the patent, which is the printed document, which is a lengthy document, or might be a lengthy document. If one looks at the file as a set of papers, there are multiple copies of an application, for example. But of the relevant documents on the question of scope of claim, there is a narrow, circumscribed set of documents. This is not like a situation where you have a statute, where you may have a very long legislative record with a dispute that's likely
or
to
negotiations with masses of emails and notes of meetings and discussions.
Absolutely not. You have a application, which you see in this case in tab 7 of the bundle we looked at, objections by the examiner, response by the applicant, and then either the examiner says that's all right or not. And after a short interchange, the applicant will either, the officer will say either, I'm rejecting you.
Here we had 2 rounds.
Here we had 2 rounds, I'm rejecting you, and you can appeal if you like.
Yep.
Yeah? You've got a perfect right to do that. Or I'm accepting you on this basis.
So what it comes down to is, it's a very unfair question in a way to put to you, and if you qualify your answer, I'll quite understand. But is one normally talking about no more than 4 letters?
Of relevance to the issue of interpretation of claims, one is talking about a very limited number of rounds of communication. I cannot say whether it's typically just a single interchange or whether it's typically more than one interchange, but one is not dealing with a file that is unduly complex. And in a sense, as evidence of that, or at least evidence of the lack of undue complexity, or perhaps more manageability of the process, we would pray and aid the fact that the AIPPI has relatively recently said, we're perfectly happy with this. Indeed, we've recommended it universally. And if I could briefly draw my Lord's attention to that, we can probably... it's in Supplemental Bundle, tab 2.
As being particularly ignorant about all this, what does AIPPI mean?
It's the Association Internationale de Practitioners de Propriété Industrielle. It's the...
That's French.
International... I'm sorry, was it that bad? I think I'll stick to English. It's the International Association of Practitioners in Intellectual Property Law. It's the most well-established international organisation. I think it's been going, well, I know it's been going for over 100 years because I spoke at their centenary.
That's still hearsay evidence.
They have study groups on various aspects of law, and then they reach resolutions.
Well, thank you very much.
And this resolution at 5021.
Where's it in the bundle?
It's Supplementary Bundle, tab 2. And you can read it for yourselves, but I would invite your lordships to mark the resolution.
That's page 3.
At 5023.
Yeah.
Right.
And the final point that I want to just address you on this
Yes, indeed.
is that there's no exclusion there suggested for amendments made on the basis of added matter. Lilly seeks to introduce an entirely artificial distinction between the kind of amendments that were made, that might be made. Under the Patents Act, there is a set of conditions that an application needs to fulfill. It's got to be new, not obvious, sufficiently disclosed. And if you're making amendments, the amendments can't add matter. And there's a policy reason for that, which is that when you filed your patent application, that fixes the date. You can't say, oh, wait a moment, I've invented something new after the date, and fold it into your patent specification afterwards. Nor can you amend it in such a way that deprives parties of the legal certainty in relation to the disclosure that's in the specification. And it's quite right to say that there is a difference between the scope of claims and what they disclose, but claims can be part of the disclosure. The central point, though, is this, that no matter where or for what reason you make the amendment to the patent, it is an amendment to address in this case, multiple objections from the office, because your lordships will recall from the file that it wasn't simply an added matter objection that was being raised. The interchange of the correspondence was in response to an initial objection to obviousness, lack of novelty, and a whole range of objections, and some of those were addressed, but in a way that was then running into different objections in relation to the file. So our submission is that there's no basis for a distinction there. The argument against life's too short, well, that's not really a principled argument. I think I've addressed the shortness of life point. One might say life is too short to do patent litigation altogether, and having to refer to a file is a minor additional inconvenience to that already large carbuncle on one's soul. There's no exclusion. There's no exclusion by the travaux, as Mr. Raphael has shown you, and sometimes the file can be of assistance. And to close on this, to follow my Lord Sumption's point, a file can be useful in saying, when we said that, we really meant it. And in our submission, it is a useful exercise in some cases.
Thank you very much, Mr. Alexander. After short adjournment, you're then taking us to the file, are you?
My Lord, I've taken you to the whole of the file.
You're not going to do it again?
Already.
No, fine.
I wasn't proposing to do it again,
Fine.
save in a very brief way in taking your lordship to the judgment in response to my learned friend's points that the judge and the Court of Appeal were in error.
Yes.
We say that the judge was entitled to use the file as a bolsterer for the other reasons that he found. In this case, there's a slight oddity, which is that, in a sense, both sides say it's not necessary.
Right.
But
Well,
you're nonetheless invited to decide the issue of principle.
That's not unusual, because if we decide we can't look, it leaves either of you naked if you need to rely on it, so that's fine.
My Lord, yes.
Good. Very well. Thank you very much. We'll resume again at 2:00. Court's now adjourned.